We always try to wait right up till 10 o'clock because we know we have a massive audience on YouTube. If you have a phone or something else that might make noise, please make sure it's on mute because it's guaranteed to go off right as you're making your most important point. We don't want to have that. We're now at 10 o'clock, so court is officially in session. My name is Jim Edwards. I'll be the presiding judge. With me on the panel are Judges Wallace and McIver. And we have one case on the docket for the 10 o'clock hour, and that's 22-3079 Stuart Longman versus Atlantic Coast Bank, etc. Typically for the appellant, we set 5 minutes as the default rebuttal time. If you want something different, just let us know. You can see the clock is in one of the Hollywood Square boxes that we have. If I see you getting into your rebuttal time, I'll try to let you know because it might not always be as obvious to you as if you were standing at the podium. And with that, we're ready to begin. Counsel for appellant, you may proceed.
Good morning, Your Honors, and may it please the court. Vincent Sullivan on behalf of appellant Stuart Longman, and Your Honor is correct. I would like to reserve 5 minutes for rebuttal. There's 4 reasons why this court should reverse and remand with directions to the trial court in this matter. And brief factual background for Your Honors, just to refresh your recollection. This stems from an underlying note judgment. Back in 2012, a predecessor of the appellee filed a note and mortgage foreclosure in Putnam County, Florida. 2-count complaint, 1 for mortgage foreclosure, 1 for breach of note. They amended the complaint, and in August of 2014, they dismissed the mortgage foreclosure count. They proceeded to trial, and a final judgment on the breach of note count was entered in September of 2014. Ultimately, in 2019, a mortgage foreclosure case was filed by, again, appellee's predecessor in interest in a separate 2019 Putnam County case, wherein the original mortgage that was sought to be foreclosed in the 2012 case was ultimately foreclosed. The debt evidenced in the 2019 foreclosure case was our note judgment in this action, and I'll refer to it as the note judgment for ease through the rest of this argument. So the underlying basis of the 2019 foreclosure judgment was the debt evidenced by the 2012 note judgment. Well, they come back to this court, the 2012 note judgment court, and they asked this court for a deficiency judgment. And we contend the 2012 note judgment court doesn't have jurisdiction, first and foremost, to grant the relief of a deficiency judgment. We contend that the note judgment itself in the 2012 case merged into the 2019 foreclosure case. If the court doesn't like either one of those items, we believe that Florida Statute 70206 doesn't permit appellee to travel through an underlying note action case to try to obtain a deficiency judgment. And we also believe the deficiency judgment they seek is barred by 9511 subparagraph 5 subparagraph H statute of limitations. We believe that the deficiency sought is subject to a 1-year statute of limitations.
Counsel, let me just make sure I understand. There was a 2012 suit, excuse me, that was 2 counts, 1 for mortgage foreclosure, which did plead for a deficiency judgment, and then a 2nd count just on the note. Count 1, the mortgage foreclosure with the demand for deficiency judgment was voluntarily dismissed, correct?
Correct, Your Honor. In
August 2014, is that when the judgment was entered in favor of the plaintiff on the note?
September of 2014, Your Honor.
Right. In the 2019, there was a foreclosure action. In that action, there was no demand for deficiency judgment. Is that right?
Correct, Your Honor. The final judgment in the foreclosure action did not reserve jurisdiction for deficiency.
So in neither case that came to judgment, was there a request for deficiency judgment? Is that right?
Correct, Your Honor.
And then in 2021, 7 years or 6.5 years, whatever it is, after the note on the note judgment was entered and final, they came back into court at that point seeking a deficiency judgment in the note action. Is that right?
Correct, Your Honor.
Okay.
So
how does that make sense?
Well, Your Honor, I contend that it doesn't, and we're going to start because I think the easiest logic to follow here is the lack of jurisdiction in the 2012 note judgment case, because there was no specific reservation of jurisdiction. And this court has said in Bank of America versus Nash that a trial court may not award relief that is beyond the pleadings nor tried by consent of the parties. Here we have neither one of those exceptions. There was no operative pleading that requested deficiency judgment in the 2012 note action case. Moreover, when they moved for a deficiency judgment some 6.5 years later, we objected, and we have done nothing but object throughout the entirety of this proceeding, both at the trial court and the appellate court level. So we believe it certainly has not been tried by consent. And we believe that's the primary reason and the easiest reason why this court should reverse and remand with instructions to deny their motion for deficiency. But
Counsel, when you talk about lack of subject matter jurisdiction, obviously a circuit court can hear a case like this. You're talking really about procedural jurisdiction because the case was closed, basically.
And Your Honor, I believe that is the more accurate jurisdiction that we are speaking about. In our initial brief, we did cite subject matter jurisdiction, but we did recede away from the language of subject matter jurisdiction. I believe Your Honor is correct. It is more procedural jurisdiction.
Mr. Sullivan, just briefly, the statute, of course, says in an action for foreclosure or in a separate proceeding. If we did not agree with you on the statute of limitations argument, would there be anything precluding them from at this point filing a separate action for deficiency?
So, Your Honor, I believe that's the appropriate way 70206 reads, is that they can travel through the foreclosure court or file, and I use the word independent action at law. Now, I know the statute 70206 doesn't use the word independent action at law. It says, and they can sue at common law, I believe is what the statute itself says. But if you look at the body of law that came out of the Dyke O'Neill cases that all speak to deficiency actions, this court repeatedly says that they have the right to travel through the foreclosure court so long as the foreclosure court has not granted or denied a deficiency, or they can certainly file an independent action. And this court repeatedly in its Dyke O'Neill cases has used the word independent action, and that's where I draw that language from. So that's the second reason why we feel like the underlying trial court improperly granted judgment, is because the procedure by which you travel through 70206 doesn't allow them to go back to the 2012 note judgment action. The statute's very clear. It provides two remedies by which they can obtain a deficiency. One, the foreclosure court. Two, they can sue at common law. The fact that the legislator identified two avenues of recourse, so to speak, excludes any and all other potential avenues of recourse. It's a maximum.
But in that you're arguing that there was no jurisdiction for the deficiency judgment claim, there wouldn't be any res judicata preventing them from going and filing that independent action at this point.
Correct, Your Honor. If they wanted to file an independent action, or if they wanted to try to go back to the 2019 foreclosure case, I believe that's what the statute permits.
But filing a motion in another case is not the same as filing another case.
Correct, Your Honor. That's our position.
Fair enough.
So, and if we look at what the 2019 foreclosure judgment was premised upon, appellee's predecessor in interest clearly states in their complaint in the 2019 foreclosure case, the promissory note upon which the 2012 case was based merged into the 2012 final judgment on the note. So that contract was reduced to a judgment, and this court's well aware, and its case law's got a long-standing position that an action upon, or excuse me, a document upon which a cause of action is based merges into the final judgment because the final judgment is superior. This court also states upon which a cause of action is based. Well, we posit and sit here and look at the foreclosure case and go, but for the note judgment being used as the primary source of a debt in a foreclosure case, the 2019 foreclosure court couldn't have found a default. It is necessary predicate that the foreclosure court used the final note judgment as the basis of the debt and used it upon which a cause of action of foreclosure is based. So it's our position that even if the court in the 2012 case had jurisdiction, and even if 70206 said they could travel through the 2012 note judgment case, we still have a problem of merger. Because without the underlying note judgment, a foreclosure is not entered in the foreclosure court in the 2019 case. So we believe the note judgment itself, much like if it was a normal action where you sued on the note and an action for foreclosure at the same time, a Appellee doesn't argue with the fact that the individual note itself would merge into the foreclosure judgment. We see no difference between the individual note and the note judgment in this case as the basis upon which you can file the foreclosure action. And then again, they can travel through the 2019 foreclosure case, or they can file a suit at common law as outlined by statute. And then our final argument is for the statute of limitations. We believe that the statute of limitations was inappropriately applied by the underlying court. And we believe that the 1-year statute as amended in 2013 does bar them from seeking a deficiency in this action. Now, a plain reading of the statute, which is what this court is required to do, and is most problematic for us, would be the language that says a 1-family to 4-family dwelling unit. Now, we look through the statute and we can find no definition of the word dwelling and no definition of the word unit. We can't find a definition of that phrase. So we have to apply the plain meaning under the laws of statutory construction. But it doesn't seem to jive. What a dwelling unit is obviously something that's fit for human habitation or intended to be fit for human habitation. But it can't possibly be that they intended that a physical structure with a certificate of occupancy be on the residential real property for this 1-year statute of limitation to apply. Alachua County versus Expedia by the Florida Supreme Court says that this court is allowed to look at legislative intent if the plain meaning of the statute clearly contravenes the intent of the legislature. And what we take that to mean in this instance is, no, if we look at the other amendments that were made in 2013 to both deficiency and foreclosure laws, all of the changes, both in the rules of civil procedure and in the statute, pertain to residential property. And we defined that down because we didn't want to include multifamily or apartment complexes, but we did want to include cooperatives and condominium units.
Counsel, this was vacant land. This is vacant land, correct?
Correct, Your Honor. It's unquestioned and unargued by either party that this is vacant land in Putnam County and that it's residential land in vacant county as far as what is entitled to be built upon the property. The only, and it's unargued that there's why I said it was vacant, but the only argument becomes, does it need to have a dwelling unit? Does it not need to have a dwelling unit?
So counsel, I think the difficult language in the statute for you probably isn't dwelling unit. It might be that the statute reads residential property that is. I think that is language indicates right now, not at some time in the future, not designated to be, not zoned as, but is a 1-family to 4-family dwelling unit. How would you resolve that?
Correct, Your Honor. And I agree that is problematic because is a past tense word. But if we look at Florida Rules of Civil Procedure 1.115 that was amended around the same time as this foreclosure crisis that the state was going to, it's expansive and uses the language residential real property when defining when that rule of civil procedure is applicable. So I doubt the Supreme Court intended to include a larger scope than what the legislature intended to include under its statute of limitations in an effort to increase the efficiency of the judiciary and reduce the backlog of foreclosures and deficiency actions that they were seeing at the time. And that's why we believe that this court should utilize the Alachua County versus Expedia case and determine that a strict reading of this statute clearly goes against what the intent of the legislature was. Now, that necessarily means that this court needs to take a preliminary peek, I'm calling it, at what the legislative intent was in passing these amendments. But as we look through what that legislative...
Counsel, the facts here are there isn't a 1 to 4 family dwelling on the property. It's not close. It wasn't one under construction. They weren't waiting on the CO. It's vacant land, right?
Correct, Your Honor. It is vacant land. And that's why my opposing counsel cites the Smolkin 7th Judicial Circuit case out of my home county in Flagler, because that judge agreed, much like Mr. Harris argues today, that, listen, it's not on there. But that creates a problem in my mind for this court, because then we have to draw a bright line of, okay, when do we consider something a dwelling unit? And this court PCA'd that case when it came up on appeal, so we have no precedential value to that PCA, no guidance, so to speak, if you will. So it's our position that, we believe that this legislature intended the statute to cover real property, including condominiums and co-ops that are 1 family to 4 family. Period. It was not designed to cover apartment complexes that are generally owned by large corporations, because they have a better ability to argue and fight with banks than, your average layperson trying to keep their home and keep their children in the schools.
Okay. Do you want to save the rest of your time for rebuttal?
Yes, Your Honor.
Right. Fine. Mr. Harris, proceed when you're ready.
Thank you. May it please the court, Ben Harris for the appellee TDMA LLC. And with permission, I would like to go directly to Judge Edwards' question. How does that make sense?
Good.
Why did we proceed the way that we proceeded? And the fundamental reason, Your Honors, is that we already had that which a deficiency judgment would give us, an executable monetary judgment, because of the somewhat unusual, I guess, way that this matter arose and came to be. The money judgment, the monetary judgment, the executable monetary judgment preceded the foreclosure judgment. So very often, for example, we do find ourselves, I represent creditors for a living, and we do find ourselves with executable monetary judgments, and then we obtain partial recoveries, whether that is by a settlement, whether that is by some sort of short payment, whether that is by execution on an asset. And at that point, if we are to do further execution on the judgment, we do go back to the monetary judgment court. We do apply the credit. We do have the new amount set, and then we go back to recovery. And so that is why, in other words, how does that make sense? That is the procedure, other than the fact that this was a mortgage foreclosure. And there's no dispute here that the mortgage continued to secure the judgment. There's no dispute that this mortgage secured this collateral. Other than the fact that this was a mortgage foreclosure and that the asset that we were taking was subject to a mortgage, and the lien we were foreclosing was our mortgage lien as opposed to our judgment lien, there is no other difference. There's also no difference in the way that the trial court, the monetary judgment court proceeded. They had in that form every opportunity that they would have in a deficiency motion in the foreclosure case, which would have been before the same court. I can't remember at the moment whether it would have been before the same judge, but before the same court. Or in a separate action, which also would have been brought in the same court. In other words, they had an opportunity to contest, which they did not do, our evidence of value, and to raise any of the other issues that could have been raised in opposition to the entry of the deficiency judgment. And
Counsel, let me interrupt you there. In neither the note case or the foreclosure case, did you request or demand a deficiency judgment, correct, originally?
in terms of it being actually brought to a decision point with the court, that's correct. I believe in the underlying note case that resulted in the monetary judgment, there was a foreclosure count that was voluntarily dismissed, as the court has previously noted.
Right, and that's the only one that requested a deficiency judgment in its prayer for relief.
Yes, sir. I believe that is correct.
Well, how do you go back to a case that's been closed for 6.5 years and, you know, say, hey, let's get started up again. Let's do something here.
But again, Your Honor, in terms of how we viewed it in any event, and I certainly did not see any law, existing case law that prevented this. We viewed it as applying a credit for the value of this collateral. In other words, if we were to move forward and our client, as the appellant notes in its brief, this debtor, the appellant, has assets, we believe, in Connecticut. And so this evolved out of an attempt to execute on the judgment in Connecticut. And we had to, at that point, apply the credit to have the proper amount and a properly executable judgment in Connecticut to move forward. And had we, for example, Your Honor, received a partial payment or found a car to levy upon, that would have been done and that credit would have been applied in the monetary judgment case in the 2004 to the 2014 judgment, the 2012 case that rendered the 2014 judgment. That was where the executable monetary judgment existed. We did not see a prohibition on doing that. The Dyke O'Neill cases speak of an independent action. They don't speak of a new action. There already was an existing case. There already was an executable monetary judgment. The thing that would be credited against was the executable monetary judgment.
Mr. Harris, I have a concern. Where's the endpoint to the right that you have to bring this action for a deficiency judgment? It appears to me like you are pushing this out and trying to get as much time as you can to consider that. But that seems like it would have the effect of encumbering a lot of properties now without any guardrails or any endpoint as when you need to fish or cut bait.
Well, I think, Your Honor, I think the statute of limitations does that. We respectfully believe that it is the 5-year, not the 1 year. But the certificate of title, I believe, was issued September 23rd of 2019. I think to pursue a deficiency in any form, we would have the 5-year period under Section 9511, not the 1 year period. We do believe this, as the court has noted, this is a vacant lot. This is not a 1 to 4 family dwelling unit, so that the 5-year period applies. So we would have the 5-year period in which to seek a deficiency judgment.
Correct me if I'm wrong, the foreclosure action, was the judgment there entered by default? I think that's what it says in the title. Is that correct?
I believe that is correct, Your Honor. I've been looking at the brief. I believe that is correct.
I mean, I know that's what I'm pretty sure that's what it says, but I tried to look in the record and I couldn't find why it was a default judgment. But does that matter at all?
I don't think so, Your Honor. I think it's a judgment of foreclosure. I think the sale was held. There's been no challenge to that judgment. There's been no challenge.
But again, in that particular judgment, in that case, correct me if I'm wrong, there was no demand for deficiency judgment in that case, was there?
There was not, Your Honor, and we handled that case, and our thinking was the reason to demand a deficiency judgment would be because we would need a monetary judgment to execute upon after the foreclosure, and we already had that. And so that it would be a matter of applying a credit for the value of this collateral that had been foreclosed upon.
Right, in which case you would file a partial satisfaction of judgment for the $4,000 or whatever it was that was bid on the property. And I'm not saying that's necessarily the amount, but you don't go back and get a deficiency judgment. You file a partial satisfaction of judgment, right?
Yes, sir. I had to make the court in Connecticut happy, to be honest with you, Your Honor, and I don't mean to be at all cursory about that. I think you're exactly right. I think it was a matter of having some sort of partial satisfaction or some sort of credit applied. The opinion that came from Connecticut spoke of a deficiency judgment. And Your Honor, in representing my client, we certainly didn't want to send back to Connecticut something that didn't have the phrase deficiency judgment. But in terms of the substance of the procedure, you're exactly correct. They were given in that proceeding. They had every opportunity to challenge the amount that we contended was the appropriate value. They did not do that.
But how do you come back 6.5 years later into a case that's done and over with? I mean, the note case was done and over with.
Well, yes, sir. We had to, in effect, reopen to apply the partial satisfaction that you speak of. Exactly.
By what right? But by what right? Could you come back 30 years later and reopen it?
Well, Your Honor, we move to reopen often when we do find assets. That does happen. Now, whether we could do it 30 years later, and I don't think if we are talking about in a mortgage foreclosure context, a deficiency, if applying the partial satisfaction is a deficiency judgment, then I think we probably are wed to the 5-year period to do that. From the issuance of the certificate of title. So I think there are guardrails.
5 years from when the foreclosure judgment issued, or 5 years from when the money judgment issued?
From when the certificate of title, I believe, is the operative word. The statute used the word certificate, and if I'm remembering correctly, the court's decisions have said that means certificate of title
But
coming out of the foreclosure sale.
If you're suing under the foreclosure judgment, the remedy there was a forced sale, correct?
The remedy to foreclose, yes, that is a forced sale. That is correct.
All right, and eliminate them having any right to the property in rem and all the rest of that. So how was that obligation violated? You got your forced sale, their title was eliminated, everything you were granted in the foreclosure judgment, you got. There's nothing left to get from that. Under the money judgment, I understand you're still owed the money. You could still execute on it for a while, but if you're saying the money judgment is what you're trying to execute on, wasn't that issued back in, may have the date wrong, wasn't it 2014?
Yes, sir, and it's still alive. Obviously, there's a 20-year period to execute on, to bring an action on a judgment.
Well, I understand that, but that's not what you're talking about. You're talking about 5-year statute of limitations on a written obligation, like the promissory note still existed.
No, sir. I think in terms of the 5-year, and my apologies, is the 5-year period to bring a deficiency action after the certificate of title is issued, is what I intended to say, and I apologize. If I did
All
not.
right, okay. I'm with you now.
But in any event, Your Honor, the substance is exactly what you identified. In other words, this was a matter of applying a credit. I do not see, respectfully, any limitation in case law or 70206 or anything else that says you may not, in this circumstance, proceed the way that we did to apply that partial credit. In other words, the question is, you're coming out of you've foreclosed a mortgage as opposed to levying on an asset through your judgment lien. That is the only difference, but it is a difference. And so the question is what you get in terms of the order applying the credit, is that a deficiency judgment? Well, if it is, fair enough, then, but I see no impediment to taking that in the case in which we already had an executable monetary judgment. It's a more efficient procedure. We certainly did not see a statutory or case law bar, or we would not have gone in this direction, that prevented us from doing it. It's unusual, Your Honor. I had exactly the same thought. Not that my thinking is necessarily relevant, but exactly the same thought that you did. This is a matter of applying a credit, but I was looking at an opinion from Connecticut that used the words deficiency judgment, and it was a mortgage foreclosure case. And so we proceeded that way. We gave them every procedural protection in terms of the fact of the matter and how the proceeding unfolded. They had a deficiency hearing. They were not, there was no right they would have had, or no procedural right or substantive right that they would have had in a deficiency hearing in the foreclosure case had we gone that route, or that they would have had, other than, I guess, service of process of a new lawsuit, that they would have had in a separate action. In other words, they had every right to contest anything that a defendant can contest with regard to the issue of a deficiency. They chose to contest none of that.
But when you read 70206, to sue at common law, that sounds like something either in the present tense or perhaps even in the future tense. And didn't they contest the fact that you're coming back into a case that's closed to try to revive it when the court doesn't have ability? I mean, after the judgment's entered, the time for motion for rehearings passed, the time for an appeal has passed, unless there's some specific reservation of jurisdiction, which may or may not work. We didn't even have that here. I mean, at that point, the case is done, it's closed, it goes in a box, and you can't, there's nothing anybody can do with that case anymore. If you want to file a partial satisfaction of judgment, that's really kind of goes to your point. You have 20 years to enforce a judgment. But in terms of reviving the case and doing anything else, you know, aren't you done at that point?
Your Honor, respectfully, I don't think so, because for example, Your Honor, were we, and I'm watching my time, were we to have found a piece of property not subject to our mortgage, to which our judgment lien had attached, we would have to proceed through that court to get permission to levy and have a sheriff's sale of that property. There's no other court, there's no other proceeding for us to go through. We would have to, if we thereafter identified yet another piece of property or an automobile or something like that, again, we would have to go through that court.
Right, to get a writ of execution and to go forward with the sheriff's sale, that's enforcing your judgment. But to get a new judgment, a new deficiency judgment, you know, that's not an execution on a judgment.
Yes, sir, but it involves the same process. In other words, we would have to at each stage establish, if we had levied on property A, that property A was not sufficient to satisfy the judgment, then therefore we were entitled to go after property B. The process, there's no difference here, except that the lien that we were foreclosing or levying upon was a mortgage lien instead of our judgment. That's the difference. And so the question is 70206, which creates two ways that a deficiency can be sought, but does not appear to contemplate this situation, just doesn't seem to speak to it. Says that it can be done in the mortgage foreclosure action. It says that it can be done by suing at common law, or have the right to sue at common law. It does not say this cannot be done if you already have an executable monetary judgment, that you cannot follow this process. And it was in substance and in every other respect, except for the use of the word deficiency, it was a matter of doing what I just described, which is.
Please explain this to me. What would be the difference in the judgment you have now on the note, plus the post-judgment interest that's accrued, versus what you would get with a deficiency judgment? I mean, what's the difference?
There's not. I don't think, Your Honor. I mean,
then why did you do it? Again, I'm trying to make sense of this whole proceeding.
Yes, sir. The why is that we were trying to apply the credit to do the partial satisfaction, and we were trying to make sure that the document that went back to Connecticut was something that Connecticut would recognize as what the court there seemed to require, which was a deficiency judgment.
And you could not have obtained the deficiency judgment through the foreclosure case that you had already filed down here?
Well, I think at that point, we had not requested it in the pleadings. We certainly, I guess, could have attempted to do that or filed a separate action. We thought the most efficient process was to do what we did, which was to go where we had the executable judgment, apply the partial satisfaction, have a judgment that came out of that could be taken to Connecticut that was, in the eyes of that court, executable. And that's why we did it. I'm down to a minute and a half. I on the statute of limitations issue, I think the court has raised the question that, is the deciding question. It states, is a 1 to 4 family dwelling unit. This property clearly is not. That's been in our brief, so I wanted to make sure I made that point. But back to Judge Edwards' question, again, had we done this through our judgment, then the process we followed was correct. So the only difference is, does there have to be yet another lawsuit? Or are you bound to the foreclosure, the separate foreclosure case? Are you bound to that because you are executing on your mortgage lien as opposed to your judgment? That's the only difference, and nothing in the wording of 70206 says that you are limited to those two means. 70206 was written with the assumption, it appears to me, of a case in which the note and the foreclosure judgment travel together, and there has not already been an independent judgment on the note. It just does not deal with this situation.
Do you agree with your opposing counsel that if things don't go your way today, that you could go out tomorrow and file that independent suit under 702 and go forward?
Yes, I do, and I'm at zero. So
Right. Okay, thank you. And Mr. Sullivan.
Thank you, Your Honor. And I'll just start with 9511 because that one's probably the easiest decision for this court to make. If the statute's clear on its face, then this court can't peel back the layers of the onion and look at the legislative intent. So if this court decides that it's absolutely clear that a structure must already be on the property, that is a 1-family to a 4-family dwelling unit, and that dwelling unit is unambiguous, that's correct. I concede the point that we lose there. But if we find that in strict application of this statute creates an untenable result with the intent of the legislature, then I think we prevail because it was intended to expedite things. Now, going to Judge Edwards's line of questioning about, well, what's the difference between executing on the judgment versus going through a mortgage foreclosure? The only difference, which is minuscule in appearance, but cataclysmic, if you will, in application, is that the legislature created a section of mortgage foreclosure law specifically designed for deficiencies and foreclosing a mortgage. That means the legislature intended to treat mortgage foreclosure actions differently than standard executions and sheriff sales. Our contention the entire time is if they didn't want to have to deal with the deficiency action that they're currently dealing with, they should have just executed on their monetary judgment rather than trying to enforce their judgment, judgment or their lien that they had vis-a-vis the mortgage. They could have simply satisfied it. They were the owners of the mortgage if it was a title clearance issue, and all of this goes away. And Judge Edwards correctly points out, if they just filed a new action at law, the only argument we have left is whether or not 9511 still applies. Which version of 9511? Is it the 5-year or is it the 1-year? And, I posit that it's intended to increase the efficiency and decrease the backlog on the judiciary, and a strict application of that would kind of create an untenable result. Merger is the most unique argument here. And I couldn't find any case law, and I've done numerous hours of research, and I didn't see anything in the answer brief that discussed saying, listen, a final judgment on the note merges into a final judgment in the foreclosure action. The case law out of the Fifth is very clear. A deficiency action is an action on the foreclosure judgment itself. So we know we can have causes of action founded on judgments. This court's already said that, and it's abundantly clear. So the fact that the underlying foreclosure judgment was based upon a note judgment renders the name difference meaningless. Whether it was a note judgment or the actual note upon which the 2019 foreclosure suit was based, it doesn't matter. The underlying documents upon which that lawsuit is based must have merged into the foreclosure judgment rendered by the trial court in the 2019 case, meaning this 2012 action loses its independent identity and becomes a part of the 2019 case. And unless your honors have any questions, I will go ahead and end early.
As my colleagues do, I will say thank you both, and we will be in recess. Thank you.
Thank you.